All right, good morning, everyone. The Iowa Utilities Commission is now in session. My name is Sarah Martz. I'm the chair of the Iowa Utilities Commission. With me today are Commissioners Josh Burns and Eric Helen. It's 9 a.m. on August 20th of 2025, and this is the time set for the Commission's August monthly meeting. Just a couple quick items on the restarting of these items. Can you not hear me in the back? Are we able to turn up volume at all? Is this better? Test, test. No? We can bring the mic closer. Okay. Is this better? Okay, great. So we are restarting our monthly commission meetings after a hiatus. Part of this is the desire of the commission to be more transparent and have a more open decision-making process. Obviously, I have also heard from the public, from stakeholders, and from the governor that bringing these back is desired. It's kind of like getting a big machine up and running again when it's been sitting in the shed for a while. So we may have some bumps or some things that need grease. We'll continue to improve the meetings as we go forward. One example is I know we had the agenda at one spot in our website, but not the monthly meetings landing page. So we'll get that corrected for next time. So in addition to the monthly public meetings, we're also taking additional steps to have more transparent decision makings. So we will also be planning to have more deliberation meetings and other discussions in public, and those will be, you'll hear more about those in the coming weeks and months. All information for the monthly commission meetings will be found, for these monthly update meetings can be found on the website, and all public meetings will be publicly noticed in accordance with Iowa Code Chapter 21. And just wanted to thank our staff for the preparation for this meeting as well. It's been a staff-driven effort to get everything up and running again, to figure out the format. And just wanted to thank from the support staff in this room, to the staff giving updates today, to our staff watching from conference rooms upstairs to give more room for in-person participation. Just thank you to everybody for your help. At the end of this meeting, we will have designated time for public comments. Public comments must be made in person and are to be no more than 3 minutes for each individual who chooses to speak. There was a sign-in sheet in the lobby in which you could inform the commission if you have public comments. At the time we get to the public comment section, I will call the names in order of the individuals that they have signed up. And at that time, you'll be able to come up to the podium and make your public comment. If you have not signed up to do public comments and you would like to, please stop by that table in the lobby before we get to the public comment time. So we will begin with a motion to approve the previous monthly commission meeting minutes. I move for the approval of prior commission public meeting minutes. Are there any objections? Hearing none, the minutes are approved. Next, we have discussion items, starting with Ms. Russ and the Administrative Rules Review. Ms. Russ?
Thank you, Chair Martz. My name is Carrie Russ. I am a utility attorney with the Commission, and in January 2023, Governor Reynolds issued Executive Order 10, which required the Commission to do a comprehensive review of all of the rules that the Commission has. And the Commission's Title 199 is required to be completed by December 31, 2025. And all of our rules after the review became effective July 16th. So we are complete with our Executive Order 10 review. There's a rule report due to the governor's office September 1, and that was sent over to the governor's office also on July 16th. So all of our Executive Order 10 requirements have been met at this time. there's still a moratorium on our rulemaking until January 1, 2026. However, with the reading of the executive order, I believe that that just requires us to not move to the notice of intended action stage of any rulemakings. So my proposal is that because we have a municipal electric chapter, I would like to work with stakeholders on starting our municipal gas chapter that we have not been able to do, which would be chapter 28. Right now, chapter 28 is reserved, and it would follow chapter 27, which is the municipal and co-op electric. And one of the new items with the rules for all of the rules is that they now sunset automatically 5 years after the last time the chapter has been reviewed and adopted whole. So I'd also like to open chapter 27 at the same time. Hopefully that will make it easier on the municipals. So that way the electric and gas will be on the same 5-year rotating period. And that way our staff and OCA who reviews those chapters will know that it's on the same period. And if you have any questions, I can answer that.
Great. Thank you, Ms. Russ. And yeah, thank you to staff for getting that review done ahead of schedule. So we love to be ahead of schedule. Commissioner Burns, do you have any questions?
Yeah, just quickly, Ms. Russ. So in terms of the munis and synchronizing, I understand trying to synchronize the gas and electric. Have you talked to them at all about if that would be something that, I'm just thinking back to my days and it might be double the work. It might be easier if I had it staggered, but maybe not. I don't know. I'm just posing that question to you.
I did speak with Tim Whipple with IAMU, and because he had also, he doesn't work with IAMU, but he does represent them a lot before the commission. And we talked about how, as far as like the rule sections, how he would like it'd be easy for the municipals that need to review the chapters if 28 mimics 27 a lot, and to help with that as well if we review them at the same time that way. And he did not seem to have an issue with it being like double the work. At least he did not express that concern when I spoke with him.
Okay, thank you. And I'd also echo what Chair Mark said, that kudos to everybody that got that EO10 done in such a not expedited, but efficient manner. I know that it was done and it was done right, and I'm thankful that you guys did it all and got it done in the time frame you did.
Thank you.
Any other comments or questions? All right. Thank you, Ms. Russ. Ms. Weisenbach for the legislative session update.
Good morning. I do have some slides. We're waiting for those to come up on the screen. My name is Stephanie Weisenbach. I'm the legislative liaison for the Iowa Utilities Commission. And in my time today, I'm going to provide an introductory overview of our legislative activities that I coordinate on the agency's behalf and some information on the session. This is consistent with our intent of this meeting to improve transparency into the IUC's work. First, to clarify, the title legislative liaison is common within state agencies. Agencies often have one or more designated individuals who may have that title or a different one, but fulfill a similar purpose. I am the only legislative liaison for the IUC. I do have some responsibilities outside of legislative work. I am one of several points of contact for external inquiries and requests. We also have a customer service bureau and communication staff. Most inquiries are managed through these channels here, especially depending on who is inquiring. I'm going to briefly review my legislative role before providing session-specific details. I serve as a point of contact for the Legislative Services Agency, or LSA, which is a nonpartisan agency that provides information and services to the legislature. The legislature's website, managed by LSA, is also a portal where I maintain an account on our behalf. The IUC is required to upload certain reports, such as our annual report required by statute, which is also on our website. I also use the portal to register on bills, which ensures we receive notices about meetings, amendments, and related changes. This helps fulfill a key responsibility of mine, which is monitoring active bills. I monitor bills that impact the IUC directly or through executive branch or governmental agencies more broadly. I also monitor impacts to types of stakeholders or topics that intersect with our work. Examples of direct impacts to IUC that we evaluate are in regards to proposed changes to processes or requirements associated with cases that come before the commission. We also have a role in providing information and education to the legislature. My role is not as a traditional lobbyist in the typical sense, as we limit actual advocacy work. It is the IUC's job to follow and implement the bills that are signed into law. This positions us to be a resource for information about our activities, jurisdiction, the role of the commission, and what may ultimately change as a result of proposed legislation. What this looks like in practice is we receive inquiries from legislators, LSA, or our caucus staff, and coordinate our responses through engaging our subject matter experts within the agency. Inquiries may be about specific impacts, interpretation of our jurisdiction, or information on the types of cases impacted by the content of a bill. In addition to receiving inquiries, legislators occasionally want to hear from commissioners directly, particularly during the process of Senate confirmations for their position. It is common for the IUC chair to give a presentation each year to commerce committees and the administration and regulation appropriation subcommittees. Each year, agencies may pre-file legislation in advance of the following session as a request for a bill. After this request, this process involves drafting the bill by LSA, review and decisions by legislative leaders, and identifying a bill sponsor. When those proposals become legislation, the bill webpage typically has a link on the left side titled Department Memorandum, which explains the bill. An IUC pre-filed bill would be the focus of direct advocacy and lobbying efforts to encourage passage of legislation. Now that we've covered some basics, I'm going to transition into some session-specific information. The 2025 session was my first session being in this role at the IUC. The IUC's pre-filed bill in 2025, House File 304, did not pass. It proposed eliminating certain outdated telecom jurisdiction and modernizing language about the forms used for electric franchises, which are essentially permits for electric transmission lines. 2025 was an active session on bills for the IUC to monitor. I registered on a total of 51 bills in the LSA portal. There were additional bills impacting the executive branch or governmental entities more broadly that I also monitored for us, although not as closely. Ultimately, no legislation was signed into law with a direct impact on IUC's jurisdiction or proceedings. So there isn't much to say yet about the 2026 session, but we are currently in between two sessions of the 91st General Assembly. Bills introduced in 2025 are eligible for consideration in 2026, but that doesn't mean every bill will pick up where it left off in the process. We also expect some priorities to shift and new bills to be introduced that we will monitor. The session is currently slated to convene on January 12th, and the 100th day of session would be April 26th as scheduled, but as we saw evidence of last year, it could run past then. The timetable is subject to change and is available on the legislature's web page on the homepage under popular publications, if anyone is interested in monitoring that. So in closing, thank you for the opportunity to present to you today, and I can take any questions.
Thank you, Ms. Weisenbach. Any questions from commission? Okay, thank you. Next, Mr. Giddens will present on RTO and federal regional updates.
Thank you. Thank you, Chair Marks. Good morning, Commissioners. I'm Eric Giddens. I'm the Federal Regional Coordinator here at the Iowa Utilities Commission. And I'll provide a very brief overview of our federal and regional work here at the Commission and some of the most current topics we're focused on. Sorry. Here we go. So first, for the benefit of the public, I'll share that the work we do here at the IUC is not done in a vacuum. Some aspects of utilities are regulated at the federal level and some are regulated at the state level, like the work we do here at the IUC. So it's important for us to engage with federal agencies like the Federal Energy Regulatory Commission, or FERC. Similarly, our electric utilities operate within large regional electricity grids that are operated by what are called regional transmission organizations, or RTOs. The RTOs, which our Iowa utilities are members of, are the Mid-Continent Independent System Operator, or MISO, and the Southwest Power Pool, or SPP. It's important for the IUC to engage with these RTOs on policy development related to issues like electricity generator interconnection, transmission planning, cost allocation, which is a term we use for determining which ratepayers will pay for projects and how much they will pay, and resource adequacy, which is a term we use that refers to ensuring the reliable supply of electricity to help us keep the lights on. Because their policies in the RTOs impact our state and our ratepayers. So just a few statistics about each of these RTOs. MISO, start off with, serves 15 states and the province of Manitoba. That's a good image there that shows how big these regions are. Serves 45 million people, 77,000 miles of transmission lines. There are 56 transmission owners that are members of MISO, 173 non-transmission owners. Over 550 different entities participate in this wholesale electricity market. There are a variety of committees and work groups, some of which are listed there, that are the opportunities for stakeholders to engage in the policymaking matters before MISO. And I don't have on the slide here, but I wanted to mention that the organization of MISO states is we call it OMS. We use a lot of acronyms around here. OMS is the body that represents the state's interest with regard to policymaking issues related to MISO. And our representative here from Iowa, from the Iowa Utilities Commission on the organization of MISO states, is Chair Martz. The other RTO that has a smaller footprint in the state of Iowa, but is still very important for us to stay engaged with, is Southwest Power Pool. SPP operates in 14 states currently and is in the process of expanding. And that's a really notable thing, how much SPP is expanding. Currently, it's the green area. It's expanding in stages to the west. Next year, we'll add Wyoming, Colorado, Utah, and Arizona. So the current footprint covers 100 utilities, 66,000 households, 9,000 businesses, 5,000 industrial customers. When it expands, you'll see that it'll cover most all of the West, except for California, which has its own independent system operator, which is another term for RTO, and then parts of New Mexico, but the rest will be covered by SPP. The states committee in SPP is called the Regional States Committee, or the RSC, that represents the state's interest with policymaking before SPP. And our representative on the SPP RSC is Commissioner Burns. So just a few quick issues that we are currently monitoring. First, in MISO, wanted to share that the expedited resource addition study process we've been engaged with for a while now. That's a fast track process to get new electricity generation online through a quick study process to study the impact of that generation on the transmission grid. And these new projects that are going through ERAS, or the Expedited Resource Addition Study, are needed urgently for resource adequacy or reliability needs. The first application window for the ERAS process was between August 6th and August 11th. The interconnection studies for that cycle will kick off on September 2nd. One of the requirements for entrance into the ARIS process was that a relevant electricity retail regulatory authority, or ARERA, must verify that the load that generation is going to serve is indeed in the footprint of the state, and that it will address a resource adequacy deficiency that's noted and documented in the state. So we had a few different projects that were submitted to us here for verification, and we processed those in a timely manner. We got them back to the applicants so that they could put that in their overall application package to MISO. MISO will share at the end of August, sometime at the end of August, how many overall projects they received in this ARIS study cycle. So we're eagerly kind of awaiting some information on that. Another issue we're working on or tracking has to do with load modifying resources, or LMR testing requirements. MISO has a new policy that requires real power testing for LMRs, but it includes a testing waiver for retail programs overseen by a regulatory authority like us for the 2026 and 2027 planning year. Voltus and Advanced Energy United opposed that testing waiver. And I'll note that the organization of MISO states, OMS, is currently in the process of creating comments to respond in support of the testing waiver. Next issue, very current kind of hot topic issue, is that 5 of the MISO states, North Dakota, Montana, Mississippi, Louisiana, and Arkansas, filed a complaint at FERC against the business case that MISO made for the Tranche 2.1 projects that are part of their long-range transmission process. Again, this is a very active topic, and we are monitoring that issue and impact that it could potentially have on Iowa. And the last one I'll mention in the MISO footprint is an order that the Department of Energy, the Federal Department of Energy, issued forcing, this was issued in May, forcing the coal plant in the Consumers Energy portfolio in Michigan to stay open past its scheduled retirement date. There was no mechanism for allocating the additional cost for keeping that coal plant operational. So Michigan appealed to FERC to ask that those costs be spread all across the MISO North and Central regions, and that would impact us here in Iowa. Since this slide was made, FERC did rule on this appeal on Friday of last week and agreed that those costs could be allocated across the MISO North and Central footprint. So that will impact our ratepayers. We're waiting for more information now on exactly how that will be implemented and exactly what those costs will be. We won't know until the end of the summer how many, what kind of costs were incurred to keep that coal plant open. And then finally, in Southwest Power Pool, just wanted to mention that the Regional States Committee met 2 weeks ago in Kansas City. I'll fly through the items that they approved in that meeting. First had to do with targeted market efficiency projects, which are region-wide cost allocation for transmission that relieve congestion and have a 4-year payback period based on the avoided costs of congestion. Second policy that was approved has to do with a safe harbor review that was waived this year. That covers the requirements for LREs that want to get base plan funding for transmission projects. That funding is limited to $180,000 per megawatt, and it has to meet 3 different criteria. 20% of the 20% or less of the designated resources in the project have to be wind. 5-year minimum term of commitment, and 125% or less of the load to be served for all of the designated resources. Fourth thing that was approved at the RSC meeting had to do with the consolidated planning process. And the specific item had to do with grid contribution cost allocation for generators. That's an additional down payment to connect to the grid. Will only apply to generators requesting firm transmission without a designated load. All generators will pay the base interconnection down payment now that that's been passed. And the final revision request, policy revision request, which is what RR stands for, has to do with transmission congestion rights bidding on what are called electrically equivalent system locations, or EESLs. This will close an unintended market loophole that allows for gaming by bidding on paths that connect to EESLs. Those are all very technical policy changes, but I wanted to share with you the types of things that are discussed in these states committees. And the next quarterly meeting for the RSC will be in November in Little Rock, Arkansas. We'll look forward to working on issues that will be before the RSC then. And that's all for my presentation. I appreciate the time and happy to answer any questions you might have.
Thank you, Mr. Giddens. Any questions?
Yeah, so appreciate this. I think one of the things that as Sarah was giving her, or Chair March was giving her analogy of like, we're bringing out this machine. I was thinking of like a big old international combine coming out of the shed, an old 815 that hadn't been used for a long time. And so as we bring this machine back out, one of the things that I hope we can do is exactly what you just did, is help educate the public more on some of these other things that we do at the commission. And I think when it comes to the electric side, especially in the RTO world, it does get, as you just showed us, very technical. I would just back up a second and just ask, just kind of laying the foundation a little bit on the RTO world, so that the public, if we have individuals in the public that are listening online and whatnot today, to better understand how the grid works. So, and I know we have representatives in the room today from Alliant Energy. I see an individual from ITC. So when those companies build transmission, who owns the transmission system? And who manages the system?
Yeah, so the transmission system is owned by the companies that build them, but they turn over the operation of that system. If they participate in an RTO, they turn over the management and operation of that system to the RTO. So again, the RTO is a big region that is a network essentially of transmission lines that are owned by a lot of different entities, but all of those entities have turned over operation of their lines to this grid operator that we call an RTO, so that the electricity generated and fed into that transmission network can be spread across this region, and the benefits can be shared amongst all of the states and the entities that participate in the RTO. So does that answer your question?
Yes.
Burns?
I'm throwing you a softball question there so that we can help educate folks. But so if, just an example, so if we have 100 megawatt solar farm, those electrons are being produced, they go onto the grid, and once they're on the grid, do you know where they go? Once they're into the RTO?
No, it's impossible to track individual electrons. Yeah, what we do know, customers use electricity. We know the amount of electricity that's pulled out of the grid, but I remember an analogy that was helpful for me when I was learning this stuff in the past, was kind of thinking of it like a bathtub. And pouring water into the bathtub is the generation of electricity that gets dumped into this grid, and then you've got lines that are coming out of it and being used. Very difficult to track individual molecules of water. They get lost in the process, but that's how it all flows.
And so there's,
And I will
go
point
ahead.
out too that it's very electricity is a very interesting topic because it has to be used at exactly the same moment that it's produced. You know, the physics of electricity are very interesting. Aside from batteries and other storage mechanisms that are developing, we don't have them in widespread use right now. Aside from that, electricity has to be balanced between generation and use all the time. It's instantaneous. And so I'll just add that to the complexity of this thing.
So sometimes we hear that electricity produced in Iowa is just simply going out of state to a place like Chicago, a big urban, big populated area. And what you're saying is we're putting it on the grid, and wherever it ends up on the grid that it's needed is where those electrons are going.
That's right.
Okay, so
Yeah, best we can do is say that, you know, we here in Iowa through our generators located in Iowa produce a certain amount of electricity in any given year. And then our consumers here in Iowa use a certain amount every year. And if there's a difference between those two numbers, then and likely we're generating more than we're actually consuming here in Iowa. That means that electricity is going outside of the state somewhere, but tracking individual electrons is impossible.
thank you. So that is one of my goals, is that I want to help do more education at these meetings and help educate the public on what it is we do and how some of these mechanisms work, because they do get very technical. And so to try to keep it at a level that, you know, we can share that information is good. So thank you. I appreciate that.
Thank you.
Any other questions?
Nope.
Yeah, Mr. Giddens, just thank you for the updates. And I was going to point out as well, for both SPP and MISO, there's multiple efforts going on right now to speed up the time that we can connect generators to the system. And that's because we're at kind of this unprecedented time of load growth and changeover of our generation mix. So I think it's just even more important for us to stay engaged in those state representative groups to help encourage policies that allow us to get the generation we need for Iowans on the grid as quickly as possible. And so didn't know if you had any comments on the MISO ARIS process and how much faster that's expected to be versus the regular interconnect queue.
Yeah, that's a good point. Thank you. It was tough to try to fit all of this into, I was supposed to do it in 5 minutes. It still wasn't 5 minutes. But,
That's my fault.
Anyway, yes, the regular study process, we'll call it, for MISO to study the interconnection of new proposed generation projects, electricity generation projects, is backed up a few years at this point. So projects that were submitted into that queue to be studied by MISO that were submitted a couple of years ago have still not been studied. And this has become a really big problem in trying to get those new generation assets onto the grid, to get them built, because they have to be studied first for their impact on the larger grid. And so that backlog is what led to the creation of a process like ARIS, the expedited resource addition study process, to try to relieve the pressure of that backlogged study queue. So as a limited process, only 68 projects are being accepted into this process. They will be studied 10 projects per quarter until the 68 have been studied. So over the course of the next few years. There were some tighter entrance requirements to get into that than what it took to get into the regular study queue. And so our hope is that getting a bunch of those projects, up to 68 of them, through that queue, in addition to reforms that are being made right now by MISO to the regular study queue process, which will help also alleviate the backlog in the regular queue process, we're hopeful we can get all kind of caught up. And then projects that are submitted for study into the MISO study process can happen in an expedited, normal fashion, and then those projects can proceed because we're experiencing load growth throughout MISO, just like everybody across the country is right now. A lot of it is AI data center driven, but there are other factors that are leading to that as well. And the only way to meet that challenge is to add new generation everywhere. And so, again, it's got to be studied. We got to get that done as quickly as we can. So hope that answers the question.
Thank you, Mr.
Thank you.
Giddens. All right, we will now turn to Ms. Raby for the litigation status report.
Thank you, Chair Martz. My name is Michelle Raby. I'm one of the attorneys for the commission. I primarily handle litigation for the agency. We have 4 cases currently in active litigation. The first one is Enterprise Products Operating LLC versus IUC, Iowa Supreme Court number 24-1648. This case arises from Enterprise's appeal of the commission's order of June 9th, 2023, imposing a civil penalty of $200,000 for each of 9 previously permitted facilities in Iowa where no hazardous liquid pipeline permits had been obtained by Enterprise after they became the owner of those pipelines in 2002. And the permits were required under Iowa Code Section 479B.73. The IUC's decision was upheld by the district court, and Enterprise appealed that decision to the Iowa Supreme Court, who transferred the case to the Iowa Court of Appeals. The case has been fully briefed. The Court of Appeals has indicated they do wish to hear argument on it, but no date has been set. I believe the dates we were given were September, October, and November, but we haven't been told which one yet. The second case is Shelby County et al. Versus Iowa Utilities Commission, Polk County case number CVCV 067849. It's more commonly known, I think, to everyone as the Summit Pipeline case. Despite that seemingly simple name, the case involves well over 100 petitioners and numerous interveners who are challenging the IUC's order of June 25th of 2024, which conditionally granted Summit Carbon Solutions petition to build and operate a 688-mile hazardous liquid pipeline through 29 counties in Iowa. The case has been briefed by all the parties. Final briefs are due on Friday, August 22nd. That's kind of a misnomer because final briefs just mean the briefs where the parties go back in and put their sites to the record. But essentially, all the parties have completed all their briefing. Once the court receives the final briefs, they will set a date for oral argument. I have no indication from the court when that will be. Sometime this fall, I assume, after the court's had time to review the record and all the briefs. The record alone in the case is about 100,000 pages long. The next case is called Swan Lake Farms versus Iowa Utilities Commission. Polk County case number CVCB 068000. This case arises from Swan Lake Road Farms appeal of the commission's granting of ITC Midwest petition for an electric franchise of approximately 4.8 miles of transmission line in Johnson County, Iowa. The case was argued back in February in district court, and we are still awaiting the ruling. The last case is Hawkeye Land versus Iowa Utilities Commission and MetroNet. It's a Lynn County case, case number CVCV 108100. This is the newest case on the litigation docket. This is a petition for judicial review of the April 17th, 2025 decision of the Iowa Utilities Commission determining that MetroNet's crossing at a certain intersection in Mitchellville, Iowa falls within the scope of Iowa Code Section 476.27, and that Hawkeye Land Company is thus entitled to damages in the amount of $750 for MetroNet's railroad crossing at this location. As the case is new, answers have been filed, but no briefing schedule has been set yet. So the next step would be for the court to issue the briefing schedule. And thank you, and that's all I have, unless there are questions.
Thank you, Ms. Raby. Any questions? All right, moving on. As the last discussion item, Mr. Davis will present monthly financials, grant spending, and offset program updates, as well as outstanding invoices. Mr. Davis.
Good morning. Thank you, Chair Martz. Commissioners Burns and Helen, Phil Davis, Accounting Supervisor for the Iowa Utilities Commission. The information before you today is a snapshot, if you will, of July 2025, fiscal 25 year-to-date expenses and revenues. I would say at this point, as we close out fiscal 25, with the conclusion of August, we'll have a conclusion of expenses that qualify. And into September, we'll have additional revenues that could qualify and will be included. So those will be discussed at our future discussions. And then we'll also fold in the beginning fiscal 26 financials at our next meeting. Overall expenses and revenues are consistent with our expectations, and we don't have any concerns at this time, but I'm happy to answer any questions.
Any questions from the commission? No?
Also there, I would like to present information with regard to the dual party relay program. This is the program that is, I guess I'll say housed within the Iowa Utilities Commission, but it is separate from the Iowa Utilities Commission work. The information here, it includes the July expenses and year-to-date fiscal 25 expenses. They are consistent with our expectation regarding expenses and revenues. There is continued, I think I would say, robust growth and interest and value provided by this program. The good news is that it is appropriately funded and has proper oversight, and I don't have any concerns at this time with regard to expenses or revenues, but happy to answer any questions.
Thank you. No questions. All right. We will now move to item number 4 on our agenda, which is other business items. And we'll start with Mr. Boyd, who will be discussing the customer contribution fund reports. Mr. Boyd.
Good morning, Commissioners. I am James Boyd, Customer Service Utility Analyst for the Iowa Utilities Commission. Iowa Code Section 476.66 requires all electric and natural gas utilities to establish a fund to supplement the Low-Income Home Energy Assistance Program, commonly known as LIHEAP, and to assist low-income customers with weatherization. Utility customers and other entities can contribute to the funds, which go by various names, such as Project Share and iCare. Each utility must file an annual report regarding its fund with the Commission. The Commission must compile this information into an annual statewide report that is submitted to the General Assembly on the first day of session. The Iowa Code does not require the Commission to verify the information provided by the utilities. The utilities reports are due by September 30 of each year. As of August 19th, 53 utilities, which is 23%, have submitted reports to the Commission. When the reports have all been filed, staff will prepare a draft letter and request a signature from Commission Chair Martz for submission of the report to the General Assembly. I'd be happy to answer any questions the commissions may have, and thank you.
Thank you, Mr. Boyd. Any questions? Okay, no questions. Thank you. All right, next up, item 4B on our agenda is upcoming events for the commission. We do have an upcoming hearing scheduled in docket number E-22547, which will be held in Howard County on September 9th of 2025. So information on that hearing can be found on the commission's hearing and meeting calendar on the IUC's website. Item 4C, we have some new staff to introduce and staff in new positions as well. First, I'm pleased to announce that Nicole Tumeyer has accepted the role of Chief Operating Officer at the IUC and will begin with us on August 29th. We're excited to welcome Nicole to the IUC and look forward to having her expertise and leadership on the team. Additionally, we have a new General Counsel with us today, Ralph Marasco. Ralph joins us from the Office of Polk County Attorney, where he served as counsel support of county elected officials and county departments while providing leadership of the County Attorney's Office Civil Division. Ralph started at the commission just this last Friday, and he is having a great time coming up to speed on all of the things that the commission has before us. So Ralph, we're excited to have you with us. And finally, I'm happy to announce that Melissa Myers has been named our new communications director for the agency. Melissa's back there in the corner. She's been with the agency for 7 years, and we are thrilled that she's taking over that role of the communications director. She's been doing a wonderful job and jumped straight into the position. Next on the agenda, we have an update from Mr. Epic on docket number NOI-2025-0001. Mr.
Thank you, Chair
Epic.
Marks. Good morning, Commissioners. My name is Michael Eppink. I am an attorney for the Iowa Utilities Commission. As Chair Marks stated, I'm before you this morning to provide an update on docket number NOI 2025-0001 regarding the participation of demand response aggregators in markets operated by regional transmission organizations and independent system operators. I'll start with some quick background on the docket. In 2008, the Federal Energy Regulatory Commission, or FERC, issued order number 719, which required all RTOs and ISOs to allow third-party aggregators to bid retail customers' demand response resources into the wholesale electric market. FERC Order 719 also allowed relevant electric retail regulatory authorities, or RERAs, to essentially opt out of the order and prohibit third-party aggregators from bidding demand response in the areas that they have jurisdiction over. In 2010, this agency, acting as the RERA for Mid-American and Alliant, elected to opt out of FERC Order 719 and essentially put in place a prohibition against aggregators of retail customers' demand response. That prohibition is still in place today. As you are aware, earlier this year, the Commission opened docket number NOI 2025-0001 for the purpose of receiving public input on the prudence of continuing the prohibition previously established. Several stakeholders have provided comments in the docket, and staff has thoroughly reviewed those comments, and at this point recommend opening an RMU docket to continue to gather information and take the initial steps of conducting a rulemaking that would potentially lift the 2010 prohibition, and also establish rules governing the relationship between utilities and aggregators. I anticipate a forthcoming order containing staff's recommendation will be presented for your consideration at some point in the near future, and I'm prepared to hear any questions that you may have.
Thank you, Mr. Eppink. Are there any questions? No? Okay, no questions, and we will go again to you, Mr. Eppink, on the resource evaluation guidelines topic.
Yep. So pursuant to settlements reached in prior advanced rate making dockets or rate case dockets, Mid-American and Alliant have agreed to undergo collaborative resource evaluation study processes with stakeholders. In the final decision and order issued in Alliant's last rate case, the Commission stated it would publish optional guidelines on its website for utilities to follow when conducting their resource evaluation studies. The Commission stated then that following those guidelines would be strongly encouraged, and it expected that those guidelines would make future advanced rate making and rate case dockets proceed more efficiently. Staff has now completed those guidelines. However, prior to publishing them on the Commission's website, staff recommends an NOI docket be open to receive input from stakeholders before they're published. I anticipate a forthcoming order opening a new NOI docket being presented for your consideration at some point in the near future, and I'm prepared to hear any questions that you may have.
Thank you, Mr. Eppink. Any questions? No. All right, no questions. Thank you very much.
Thank you.
All right, so we have come to the public comment portion of our agenda. So I have a sign-in sheet that I'll pull up here with the individuals who have indicated that they would like to make comments today. When I call your name, please come up to the podium and be sure to speak clearly into the microphone. And a reminder that all comments are limited to 3 minutes per person and that verbal comments are not filed in any docket. So if you wish to file your comments as a comment or an objection and make it part of a docket, you are free at any time to go over just across the hallway to our customer service department, and they will help you do that. And just another reminder that commissioners are in listening mode today for comments, will not be responding to any comments. So I will get to our list. Our first commenter is Deb Main.
Good morning. Well, I'm 4 years older now than when I first stood before the Iowa Utilities Board, now the Iowa Utilities Commission, to speak of our concerns with the hazardous CO2 pipelines. Since that time, we've accumulated the largest docket in the history of the state. And I was just wondering, what can I possibly add to that you haven't already heard? But I attended the funeral of one of our neighbors yesterday, and I was handed a gift, and I will read what she chose to have read at her funeral. It's entitled My Farm. My farm is, to me, is not just land where bare unpainted buildings stand. To me, my farm is nothing less than all created loveliness. My farm is not where I must toil, my hands in endless dreary toil, but where through seed and dwelling pod, I've learned to walk and talk with God. My farm to me is not a place outmoded by the modern race, for here, I think, I just see less of evil, greed, and selfishness. My farm's a haven, here dwells rest, security and happiness. Whate'er befalls the world outside, here faith and hope and love abide. And so my farm is not just land where bare unpainted buildings stand. To me, my farm is nothing less than all God's hoarded loveliness. Thank you.
Thank you, Ms. Main. Next, we have Deb Freeman.
Good morning. My comments refer to docket 2023-0004. Because the hazardous CO2 pipeline proposed route crosses 13 waterways in Mitchell County, the Summit project should be denied a permit. The proposed hazardous pipeline would cause economic harm to the Mitchell County Conservation Services, which provided greater than $4 million of benefit to the county. This included conservation parks, Cedar River access areas, fishing, canoeing, swimming, boating, camping, and hiking. This also includes endangered species areas. We are all connected by water. The hazardous pipeline routing through these conservation grounds and the karst topography of the county along the Cedar River needs to be a rerouting away from this unstable ground. There are 1,200 sinkholes identified in Mitchell County, all on the western half. At this time, this is a pipeline to nowhere. Please deny this ongoing effort to take private land for a private LLC. Please deny this routing through sensitive grounds and waterways and excessive water taking. Thank you.
Thank you, Ms. Freeman. Colleen Tucker.
Good morning. Thank you. I'm a fifth generation landowner near Osage, which is part of Mitchell County, which is part of Iowa, and the last time I looked, it's part of the United States. My family has been entrusted to be a steward of this land for 153 years since 1872. I realized back in 1776, our forefathers could not have imagined there'd be something such as a CO2 pipeline. But those brilliant, intelligent, and prospective men knew that government is to be created to provide order, protect rights, and promote the common good. Protect rights, and that's why we are all here. The government's job is to make sure every person can safely enjoy their natural rights, life, liberty, and property. Life, no one can take their life without due process. Liberty, you can make your own choices about your job, your religion, your speech, where you go, where you live. Property, you have the right to own things, use them, and not have them unfairly taken from you. and that includes land. Both the U.S. Constitution and the Iowa Constitution enshrines these protections. I want to remind you that government's first responsibility is to protect rights, not to violate them. To protect rights, government must also limit itself. That is why we have the Bill of Rights, to make sure government works for the people, not against them. And that's why we are all here, to protect our rights as citizens of the United States. The citizens of Iowa have spoken repeatedly and loudly opposing eminent domain for CO2 pipelines. The Des Moines Register showed 78%. The Phase 2 dockets show close to 88%. And I want to remind you that most of those were inherited from the Navigator project. And some of those parcels are also owned by Summit. So not very many landowners are signing up. Even the Iowa State Fair's corn kernel poll shows that we're close to 90%. These are not just statistics. These are overwhelming mandates from Iowans. So I ask you, and I hope you are listening to the people of Iowa, that you are reading the objections in the dockets and that you are looking at the Exhibit H maps in the docket. By granting eminent domain for this project, the state of Iowa, which includes all of you, is violating our property rights. And I wonder how you can defend and justify the fact that Summit is given a permit to desecrate our land. We are ordinary citizens, and we are here because we love our land, our state, and our country. We don't have deep pockets, and we're not paying off lawmakers and decision makers. We are not paid protesters, and we feel that we are being disrespected, ignored, and brushed off by the state of Iowa. We ask ourselves every day, why is Iowa allowing this to happen to its citizens? What kind of a reputation is Iowa going to have? But I will say, we the people stand on the side of our forefathers, the Constitution, and the fundamental rights that government is to protect our rights. With a heavy heart, I ask that the IUC revoke Summit's permit. Stand with the citizens you represent, not a private for-profit corporation. Thank you very much for listening to me.
Thank you. Jan Norris.
Good morning. I'm Jan Norris from Montgomery County. Thank you for allowing public comments. I urge you to dismiss the remaining Summit dockets. Landowners should not be left in limbo while a company is given unlimited time to salvage a project that is clearly unviable. There is no route through South Dakota, and these laterals have negligible support. The few signed easements likely were acquired from the defunct Navigator project. Phase 2 landowners are saying no. My docket, 2024-006, appears to be entirely Exhibit H. Landowners are spending countless hours defending property rights. Both major political parties in Iowa oppose eminent domain for private gain, yet this board granted it to Summit for an unprecedented number of parcels. Time and again, the board has appeared to side with the company. This pipeline project is unprecedented in every way. It's the largest docket, the most objections, the longest hearing, and the greatest number of Exhibit H parcels. It has strained everyone, the IUB staff, whose customer service I commend, the legislature, the petitioner, and most importantly, the lives of the Iowans at the proposed path. Over the past 4 years, I have learned that no one is going to stick up for us. Landowners are at a disadvantage at every turn. At the Fort Dodge hearing, I heard testimony from a dairy farmer whose son can't expand their operation because the route cuts through their field. A woman who retired and planned to move home to care for her ill sister. Now her dream home is on hold. Charles City's industrial park, which earned a special certification after years of work, is now threatened. My neighbor, who was moved to tears while testifying, identified the perfect spot on his new farm to build a retirement home 35 years ago. Now that hill is where the pipeline wants to dig, destroying his dream. He fears he'll never pass his land on unencumbered. The pipeline's rights would outlive his son. We are in limbo. We can't plan our farms, make family decisions, buy or sell property. Legal fees are due every month. Our lives are on hold. Please dismiss these Phase 2 laterals. Call the project what it is, non-viable. There is no path in or out of South Dakota. Make Summit start over when they have a route that they can build. Please make a decision for us this time. Give us some relief while the company regroups. Thank you.
Thank you. Mike Henning.
Good morning. For the past 20 years or so, since Dad died in 2001, myself and my brothers have been operating or acting as trustees for my mom's operations. All has gone well since that time and everybody has been happy. However, that all changed in July last year when Mom got a series of letters from Summit Carbon Solutions. They wanted to put a pipeline across her main farm, her most productive area, about 1,000 feet out her kitchen windows, along with above ground valve that is a dangerous valve, very close. And she doesn't want it there. She was upset. She was angry. She called us kids from around the country, and we all came home to say, "Hey, Mom, what can we do here to help?" We stepped in then and said, "Oh, we got to do something to calm Mom down." She's now 94 years old, and my stepdad's 100 years old. Not a good situation at all. So it upset everyone in the family. The neighbors were all upset because they understand mom's condition, and we needed to do something. So we reached out to some of the phase one people and learned about a lawyer by the name of Brian Jordy. So we enlisted his services. We contacted Summit and told them, don't touch anything to touch Mom. We put a big notice on the storm door that said, same information, call Summit or call Brian Jordy to protect Mom. And we thought that would take care of it. Well, it didn't work. Summit still continues to send their agents out to Mom's place, make phone calls, send her letters. As recently as this month, the new CEO sent out his nice letter introducing himself, who to go to. It didn't go to Jordy, it went to Mom. She is very upset and very angry of why in the hell does she have to get involved with this thing. So please try and stop some of that. I did contact the commission this spring, and some of your people did reach out to Summit, and we thought that we had it all stopped, but no, again, the current CEO just contacted her again. So that needs to stop. Even back in March 22nd, actually, she looked out the window and saw surveyors out on her property. That wasn't a good situation at all. Fortunately, our daughter and her husband were there visiting with our new grandson, and they ran out and took the gator out across the field and called my brother who lived close and farms the ground and a neighbor, and they all came. They got the sheriff there and they got the surveyors off the ground. So we thought that was behind us. However, just the end of July, the neighbor Dale was mowing her grass waterways and came across Summit survey stakes out in Mom's field. So obviously they've been back. No notification went to Jordy, nothing to us, nothing to anybody. So the Summit is a poor communicator. They need to be stopped. Phase one landowners, as you've heard, have been in limbo for a good 5 years. Now, phase two people are suffering the same damn things that the phase one people had been suffering for 5 years. So we need to get that stopped. We appreciate anything the commission can do to help with that situation. Thank you.
Thank you. I think we might be having some technical difficulties with our timer, but we're working on it. So, Sheila Hebenstrut, and I probably said that wrong. Sorry.
That's all right. Everybody does. Sheila Hebenstrut. Number one, thank you for listening to us and hopefully absorbing what we're saying, not just bypassing us and thinking that we're not significantly impacted by what is going on here. I too have been harassed by the Summit people. After I've asked them not to harass me, they have still come to my door multiple times. They have come to the tenant on the farm and gone around me in order to do that, which is again is inappropriate. But I want to reiterate everything that everybody else has said. There's only 12% that have agreed to this, and most of them are not landowners and homeowners that will be significantly impacted by this. Myself, I just put $200,000 worth of pattern tile on my farm in 2019. And Summit's proposal goes through every one of those tile lines, which is somewhere above 40 tile lines. And then if there's a break in that tile line, I'm not allowed to fix it, which we would normally do the next day if it's broken. I have to contact them. They have to come out and they have to deal with it, which again, we would do immediately and protect our own living, our own income, which they are jeopardizing. It would be similar to if the plumber told you that you cannot touch anything in your kitchen because your pipes broke because you don't have permission from your plumber to do that, and just let the water run through your entire home unobstructed. It would be a similar situation to what you're asking us to accept. So we ask you not to allow Summit to continue with this project, to deny eminent domain in particular. We own those farms. We've owned them for many of us over 100 years in our families. Thank you very much for listening. I appreciate it.
Thank you. Megan Sloma.
Good morning. Thank you so much for this opportunity. It truly means a lot to me. My name is Megan Sloma, and I am a fourth-generation female owner and manager of farms in Sioux County. For me, this is a moment literally that is years in the making. We were notified in September of 2021 that our farm was along the route of Summit's original proposed CO2 line. After much research, our family decided that we were not going to go ahead and sign an easement. However, what happened is our neighbors signed. So that put us in the very unenviable position of being just neighbors. I was not allowed to speak at the hearing in Fort Dodge, as my petition to intervene was denied twice. Therefore, this is truly my first opportunity in all these years to speak to the IUC and fight for my family's legacy. I sat with many landowners, helping them prepare their arduous testimony, helping them file it, and watching in awe as they gathered the courage to speak live and testify at Fort Dodge. However, at that hearing, my name was never called because I'm just a neighbor, even though our farmhouse near the proposed route is very, very much within the danger zone by any admission or any plume study. My tenant's wife tearfully asked me if she thinks that she's going to be okay working on puzzles in her basement with the pipeline so close to her house. It has her absolutely petrified, and that's not right. So where does this stand today? Phase 1 of the project is in serious trouble as surrounding states are proving to be roadblocks. Phase 2 is in even more trouble with sign-up numbers at around 12%. So what we are asking is that for Phase 1, please ask Summit to provide an update on their ability to fulfill the conditions which you placed on their permit. Landowners, as has been said, we are still very much in limbo, and this shouldn't just go on indefinitely. For Phase 2, please pause the dockets until Summit can demonstrate a much greater acceptance of the project by landowners. A project with so little support shouldn't be allowed to continue indefinitely. So in conclusion, what I'd like to say is that our founding fathers did an absolutely fabulous job of granting us rights and protecting those rights. But kind of a fundamental rule when it comes to rights is that one person's right, it ends where it tramples on another person's rights. This whole issue is basically Summit's right versus the landowner's right. And I would ask that you stand up for the landowner's rights and not allow Summit to continue to trample on it. Again, thank you so much for this opportunity to speak and for your attention to this matter.
Thank you. Jess Mazur.
Hi, my name is Jess Mazur, and I work for the Sierra Club Iowa chapter, lifelong Iowan, live here in Des Moines. And I have been working with these really fine Iowan people for the last almost 5 years to protect their farms and their families. And I just want to remind you and make sure you realize that the immense power that you three have over other people's lives and their legacies and their future. Your decision could shape people's lives for the better or for the worse. It's a lot of power to be in your hands. So I kind of wanted to just make sure that you saw some of the maps that have been submitted in the docket as Summit's final Exhibit H maps. This shows a failing project, and I know you have access to this, but just want to make sure that you can see them from far away. But we have Butler County, almost completely red. No one wants this pipeline. Ida County, every single parcel is red, meaning they're refusing to sign an easement. Adams County, 100% red. Montgomery County, 100% red. Sioux County, looks like 100% at quick glance. Maybe there's one, but it looks like 100% unsigned. Worth County, nearly 100% unsigned. Hancock County, just a couple signed. Kossuth County, nearly 100% unsigned. Clay County, same story. O'Brien County, same story. The other docket that has O'Brien County, same story. Bremer County, mostly unsigned. Floyd County, mostly unsigned. And other people in the audience have some of the other maps, so I don't have them all right now. But that's the story up and down Summit's route on phase 2. People do not want this thing. We all have these Iowa values that we were brought up with of working hard, integrity, taking care of others. Remember that the decision that you three have is going to shape the lives of thousands of Iowans, and it can be for the better or it can be for the worse. Thank you.
Thank you. Weston Grow.
I'm Weston Grove from Guthrie County, rural Guthrie County. First of all, I'd like to thank you guys for resuming the open meetings to everybody. That's really goes a long ways in the transparency that you're trying to resume. Concerning the CO2 pipeline permit, Summit hasn't demonstrated a path that they have through South Dakota because of the law that they passed up there. So I don't think this should just be an ongoing forever item that everybody is in limbo about. Should be a time limit that they have to either show a path through there or the permit is timed out. In phase 2, there's not enough landowners, only at 12%. They've agreed to leases, so eminent domain should not ever even be considered to be a part of that process. Thanks again.
Thank you. Cynthia Hanson.
Good morning, Cindy Hanson, Shelby County Century Farm landowner and affected phase 1. I'm not going to say too much on phase 1 since we're in litigation on that. But I will tell you that the landowners from phase 1 are not going away. And since Summit cannot meet all the conditions that were put on them for their permit, as far as I'm concerned. It should be their permit should be withdrawn and they should have to start over. But I am mainly here in support of our phase 2 landowners who are now going through what we've gone through for the last over 4 years now. I do have one question, and I know you can't answer it, but something that maybe you can address in the future. I heard the power presentation and the increase in power generation that's going to be needed. And my question, because they said there would be a rate increase for the stakeholders, and I'm guessing that is across the board residentials. And my question is the main part of this power generation for data centers and AI centers, and shouldn't they bear the cost of that increase? And I know you can't answer questions right now, but if you could address that in the future, I'd appreciate it. Thank you.
Thank you. Layla Christensen.
Thank you for letting us speak. My father is 89 years old. And Summit wants to go through our land, wants to take it away from us. That's his income. We have renters on that land, so it's another family's income. This should not happen. And I'm asking the commission to please deny Summit permit. Thank you.
Thank you. Glenn Alden.
Good morning, and thank you for having another public meeting. In thinking about this, and going back over 4 years, it's just a matter of amazing things that a person learns about the Iowa Code and the impact that such a company will have on things besides just the landowners. I've got several neighbors, excuse me, very close to the pipeline that have no say. That doesn't seem altogether right. The rest of the state is going to be impacted by at least two things, and that's the water usage and how valuable that is, as well as the electrical use, which has come up here, and what that impact will be to the grid. And a comment I just thought of here, this ongoing for my notice was in, I think, November of 21. So it's almost 5 years. And that would be similar to the Iowa, was it revoking easement clause? They haven't done anything in 5 years, so do they have to give up their easement? Even though their easement, to me, was claimed to be permanent, state law says that if it's not done in 5 years, that we can ask them to revoke that, or we can ask you to revoke that. It's just a question. But so a lot of these things fall under something that is not a common thing, and that is the non-monetized externalities of this project. And that's the burden that's caused not only for the landowners like myself, but also the rest of the nation. Thank you.
Thank you. Betty Sullivan.
Thank you for allowing us to speak today. Our farm is along the proposed Summit Phase 2 route and is a Century farm. This is the 4th time we've faced eminent domain. The first and second were Highway 20, and they took 20 acres of our land, cutting through a 300-acre field, cut it in two, causing us to go 2 miles just to get to the other end of the field. Compensation was only for the land, but we have lost income for over 20 years on 20 acres of land. Whether we like it or not, this is a public use, though. The third was Dakota Access Pipeline that was and still is a disaster that never should have been permitted. After 8 years, we still have optimal crops. And then comes along Navigator, which is now Summit. The proposed route crosses Highway 20 and aligns with and crosses an old Clay County tile that is very fragile. It's old, it's very fragile. This is the end of the tile line and it empties into the drainage ditch at the south end of the field. It also lays in an area of quicksand. So any disruption of this old tile would affect the drainage of thousands of acres. Highway 20 has been reinforced several times as it sags down over this area of quicksand. It's a recipe for disaster that would affect the entire neighborhood as well as every vehicle traveling along Highway 20. Another concern is Summit has not gotten a simple task of figuring out who we are and where we live. Some of the mailings have even land agents has showed up in an address we moved from 11 years ago. This is very disturbing for those that live there now. If Summit can't get this basic information straight, how can they be trusted with something as complicated as a hazardous pipeline? Very few, like 12%, mostly old Navigator easements, have been obtained. Plus, there's no route to South Dakota. I'm requesting that the IUC dismiss Summit dockets.
Thank you. Sherry Webb.
Good morning. My name is Sherry Webb. I am, our land is in Shelby County. It's 126-year-old land that we've had. So my speech is not AI generated. I'll tell you that right now. It's been 2 years since my visiting granddaughter stood here and explained as the 7th generation how important our land is. In fact, here's her little speech. It's been 4 years since the initial letter from Summit came, and so we are now starting year 5. We are with phase 1. When I testified during the hearing in Fort Dodge 2 years ago, I asked how much water Summit was going to use, and that question was not and has never been answered by them. At one point, we heard 9% more, but they never explained how many gallons more that was. Over the past 2 years, one of our affected landowners has looked at ethanol plants in Illinois and used that data to compare and determine how much water Summit would need, which is a grand total estimated 3.36 billion gallons of water a year. 3.36 billion gallons of water a year. I'm not sure where that's coming from. First of all, we've never had to worry about water as a resource in Iowa. But after the last 4 years or 5 years of drought, farmers have wells dried up everywhere. And now we have AI centers, data centers coming in that needs more water than that even. Summit claims transparency, but it lacks the ability to accomplish that. They have not responded to how much electricity they would need as well. Those questions are something that should be included in their filings, in my opinion. Why are we wasting time with this project? They can't get to North Dakota. They have a pipeline to nowhere. We have lost landowners in the past 2 years, at least 3 of them. And personally, I am losing my husband to Alzheimer's, and yet I'm here today. And I was at Shelby County Supervisors Board yesterday. It's time that we get our lives back. So I thank you for listening and eye contact, all 3 of you. Thank you.
Thank you. Kathy Stockdale.
Kathy Stockdale, Hardin County, affected by phase 1, and my husband is also affected on phase 2 of the Summit Pipeline. We are now starting our 5th year of this fight, protecting our property rights. As a company that continually says that you can't change the rules in the middle of the game, I have seen them change their rules many times. In Iowa, they claimed it was for the environment. Then they said it was to save ethanol. In South Dakota, it was for SAF. And in North Dakota, they said it was for EOR, although they claimed in the IUB hearings that they would not use it for EOR. We have seen changes in leadership positions in the company itself. Lots of changes in land agents and survey crews. It reminds me of the saying of a wolf in sheep's clothing. The definition is a person who appears harmless or friendly, but is actually dangerous, deceitful, or malicious. They've just changed their CEO, but they are still the same wolf in that sheep's clothing. You granted a permit to Summit for phase 1 and put the stipulation that they need the South Dakota. Well, South Dakota has denied it twice. I wish what you had added to that was a time frame that they had in order to get that permit in South Dakota, because right now it looks like they cannot get it. They cannot use their North Dakota permit or the small one in Minnesota because those both come into South Dakota. Now we have the lateral twos. It is not fair to these landowners in phase 2 to have to be going through this whole situation because Summit right now has no path for the original route that they are connecting to, and only 12% of the people who have signed for this. Most of those are navigator easements that they purchased. The others I know in Hardin County are Summit themselves and people associated with Bruce Rastetter. It is time to say no to Summit and to deny them their permit for these new laterals. Thank you.
Thank you. Darlene Partlow.
Good morning. I'm representing my family in Guthrie County. Also, our docket is also Greene County. And just showed you maps. There's Greene County. You can see the red. There's Guthrie County. You can see the red. Only one small spot there that is a trust. If you notice, down here by the Menlo ethanol plant, you see the big red square? That's our ranch, 700 and plus acres. Why along that route is everyone 40-acre eminent domain, but it's our whole ranch? That's my question, and I think this project needs to stop. It's a project to nowhere, and the eminent domain that you granted them should be taken away. And that's all I ask. Thank you.
Thank you. Kathy Carter.
Good morning, Kathy Carter. I've been fighting this for 4 years. I'm one of the phase 1 people. I'm in Floyd County. And I can only echo what the others have said here today, and that this board's permit decision for Summit 2021-0001 was based on some highly erroneous logic of what constitutes public use or the public good. It sets an ugly, ugly precedent for abuse of eminent domain, when currently over 80% of those people on phase 2 are saying no to the project. It's mind-boggling to think that eminent domain could be applied to so many properties. With the indulgence of the landowners here, I want to move into something else. I want to talk about docket GCU 2025-0004, River City Energy. It's a solar project proposed for Cerro Gordo County. Cerro Gordo County invested hundreds of hours in research, held numerous public comment meetings, heard from hundreds of members of the public who were overwhelmingly against the River Energy solar project. As a result of the research and the overwhelming sentiment,
The county supervisors voted unanimously to ban industrial wind and solar from the county. But along comes River Energy, picks up a parcel here, an easement there, a landowner here. So instead of a single large industrial complex, they are creating a piecemeal map which they'll link together. Same end result. Against the wishes of the county and the majority of its residents. Letters of support have been from a handful of out-of-state owners, a couple of local landowners who have submitted multiple letters, and some are form letters provided by River containing signatures of some landowners who later discovered that letters were being submitted in their names without their knowledge. Commissioner Burns and Mr. Giddens, I thank you for some education today. It's been helpful. It's a very complicated process. But I heard on the news this AM on the way down that Iowa is second cheapest in cost for buying homes. We also hear continually that the mix of wind and solar will help keep Alliant and Mid-American rates down. Tell that to my stepdaughter. Single mom working full-time, kids are at their dad's 50% of the time, so there's not even anybody else in the house much of the time. Tiny 2-bedroom house, heat is LP, not electric. She has no AC, so why is her electric bill topping $550 for a single mom? It's working her butt off. At a committee hearing earlier this year, Representative James asked why a company in her district would pull up stakes to move across the river to another state where the rates were substantially lower. The answer was, we'll talk later. And we wonder why Iowa is 49th in economic development. It's time to put the brakes on the utility rates, time to stop those continual large annual increases. If wind and solar are so helpful, prove it. Prove it to the folks trying to pay these outrageous bills. Prove it to the public. Thank you for again having open meeting, public comments. It's nice to have a little transparency again.
Thank you. Beth Richards.
Good morning. I'd like to thank the commission for reinstating these meetings and committing to increased transparency. Really do appreciate that. My name is Beth Richards, and I am manager and co-owner of RKR Farms LLC. RKR Farms is a diverse family-owned 1,200-acre operation located mostly in Hardin County. It is immediately adjacent to Summit Phase 1. I'm a fifth-generation owner, and much of our land has been in our family for more than 100 years, some in excess of 170 years. Even though our land is profoundly affected by the proposed pipeline, we were denied intervention in the process by the IUC, much as Megan mentioned earlier. According to its website, the mission of the IUC is to ensure that reasonably priced, reliable, environmentally responsible, and safe utility services are available to Iowans. The proposed CO2 pipeline meets none of these mission goals and actually is a detriment to them. In addition to managing our farms, I am also an energy systems engineer and a natural resources management scientist. I can say with confidence that the Summit CO2 pipeline does not make sense. It is in fact contrary to the IUC mission statement from cost, reliability, environmental, and safety standpoints. And I would be happy to elaborate on my opinions at any time anyone wants to talk to me. It would also use a ridiculous amount of water, which should be another critical matter of great importance to the state as a whole. The more landowners and other Iowans learn about this unproven technology, the less they want it. This is evidenced most recently by the refusal of the vast majority of affected landowners to sign easements for Phase 2. And I've also heard of Phase 1 owners who really regret signing. The IUC really must reconsider its willingness to tolerate the continued efforts of Summit to try to grab other people's land rights so they can get poorly designed federal tax credits for private profit at the expense of Iowans. Thank you.
Thank you. Marty Mayer.
Good morning. I'm a landowner in Page County. When I testified at Fort Dodge, you obviously thought I was a liar or I was disingenuous, as you did not believe anything that I said. It didn't matter to you that my water source would be imperiled, or that my property values would be damaged, or that our right to live peacefully on my great-grandfather's farm would be extinguished. In testimony, I said I had an alternate route for the pipeline that would minimize the damage to my farm. 1 hour after finishing testimony, I received a call from a Summit representative that wanted to meet with me about my alternate route. I told him I would be happy to meet with him, along with my lawyer, at any time he would set up with my lawyer. Since then, neither I nor my lawyer have heard a word from anyone at Summit. You approved a section of pipeline which contains two 80-degree turns within 300 feet of each other, right across the road from my property. Do you really believe such a silly construction plan is prudent? That configuration requires additional pressure in the line to flow through this section, which adds further stress to the pipe. Bends, or in this case, corners, are notoriously prone to wear issues, and they weaken the integrity of the pipeline. Knowing that my residence and grain bin complex was in the kill zone from the pipeline, only 300 feet away, you intentionally and directly endangered the lives of my family and myself when you gave eminent domain permission to Summit Carbon for the pipeline. It is clear that for all the dog and pony show at Fort Dodge, your actions show you don't care about the lives of my family, only promoting the Summit Carbon venture.
Thank you. That is the end of the list that I have for public comment. Is there anyone we missed, just to be sure? Okay. So just for a couple housekeeping items, our next monthly meeting is scheduled for Wednesday, September 10th at 9 a.m. We are trying to make these consistently the third Wednesday of the month, but we had conflicts the third Wednesday of September. So it is September 10th for our next meeting. Information on that meeting, the agenda, and the virtual link will be available on the commission's website and on our hearing and meeting calendar. And I will just ask the other commissioners if there's any other business that needs to come before the commission. Hearing none, the meeting is adjourned. Thank you.